Good morning, everyone. This morning, we will be talking about when a PIP release is no longer a release. Post-covenant medical versus State Farm and best practices. My name's Nate Edmonds, and welcome to our webinar. I know this is a hot button issue and one that has just recently arose, so hopefully today we can answer several of your questions and give you some ideas as to how to handle claims moving forward in light of Covenant Medical. The Covenant case came out on October 22nd, 2015. It is a published opinion and therefore is binding on all courts in the state of Michigan until the Supreme Court either overrules or sends back the case for some other modification. That would be the end of story for now. The case arose out of a Saginaw Circuit Court case where State Farm had settled a prior case with its insured for $59,000. Covenant had approximately $44,000 in medical outstanding. When State Farm settled the case with its insured, it settled with a release which also included hold harmless and an indemnification clause with its insured. There had been no communication from Covenant prior to the settlement other than the submission of a medical bill to State Farm. The settlement with its insured covered all medical bills and claims through January 13th, 2013. However, when Covenant filed suit, they had done so within a year of their bills, which had been incurred in 2012, so there was no one-year back defense as it relates to Covenant. The defense simply was that the insured had signed off on all claims, and therefore that had barred the medical provider's claim. The Court of Appeals decision, which is a rather short opinion, it consisted of approximately 3 pages, dealt with the fact that Covenant could still maintain a lawsuit against State Farm because State Farm had not complied with MCL 500-3112. The Court of Appeals logic in Covenant was that State Farm had quote-unquote notice of Covenant's claim, and its payment to the insured did not discharge its liability to Covenant Medical. The panel in Covenant distinguished Michigan Head and Spine, where there was a release involved, indicating that the Michigan Head and Spine bills were incurred after a release had been done. Covenant relies upon the section of 500.3112, where the statute has indicated that payment by an insurer in good faith of personal protection insurance benefits to or for the benefit of a person who it believes is entitled to the benefit discharges the insurer's liability to the extent of payments unless the insurer has been notified in writing of the claim of some other person. Thus, the logic of Covenant is that an insurer becomes notified of the claim of some other person, in this case the medical provider, once they receive written notice of the claim. That is in the form of a bill. Once that is received, then any settlement or payments to the insured alone is not quote-unquote in good faith because the insurer did not give notice to that affected third party. I am sure many of you are well aware of the case law that indicates that the bill or the claims arise out of the insured's ability to seek benefits. However, this court has also now indicated that certain rights become fixed, such as medical providers, once they submit a bill to the insurer. The court in Covenant also indicated that it implicitly recognized in the text of the release itself, which provides that Stockford agreed to indemnify, defend, and hold harmless State Farm from any liens or demands made by the provider, including Covenant Medical. Therefore, the parties clearly knew of Covenant Medical's claim and still resolved the claim without notice to Covenant. The prior cases where the court has ruled that an injured person is a quote-unquote real party in interest to assert recovery of medical expenses under Section 3107, those cases are Aetna versus Starkey, 116 Mishap 640, 1982, and Hatcher versus State Farm, 269 Mishap, 596, 2006. However, it now appears that Covenant is extending the rights of medical providers and potentially others who have claims under the No Fault Act, that they must have notification before any settlement. We are now at the position of what to do now. Covenant's position in the case was that 500.3112 promoted full and complete settlements due to the fact that all parties must be notified and there would not be additional litigation arising out of settlement. Covenant further went on to argue that if the insurer addresses all known claims during settlement, then it ensures that its payment discharges its liability. That is what would promote efficient, complete resolution of no-fault claims, which is consistent with the purpose of the No Fault Act. Covenant cited Tinnen v. Farmers Insurance Code 287 Mishap 511, as the act is intended to provide assured, adequate, and prompt compensation for certain economic losses. Do you all understand where we're at this point? Good, because many of us don't. However, we have to deal with what we have been given, and we are attempting to make recommendations that will prevent future headaches till we receive further clarification, or, as some may say, further modification of the waters. Just as I had previously said, modification of the waters, I will also attempt to briefly address another published opinion that came out on October 29, 2015, Chiropractors Rehabilitation Group, PC versus State Farm. In this case, it cited already to Covenant Medical. You may ask, how would that panel know of it? Well, Judge Shapiro was on both panels. Judge Shapiro has also been known to have several rulings that are not favorable to the insurance industry. The Chiropractors Rehabilitation Group is another case in which providers have an extension of their rights under the No Fault Act. In this combined appeal case, the healthcare provider's ability to recover an injured party medical expenses under the No Fault Act is dependent upon an insured's eligibility for such benefits. However, eligibility is different than whether an injured party may recover benefit. In chiropractors, this was a case where at least one of the claimants did not cooperate at all with State Farm in the investigation of the claim. They did not attend independent medical examinations and did not attend any examinations under oath. The court ruled that a suspension stood until the insured complies with the investigation. However, a medical provider still could go forward with their claim, provided that they had medical records which were submitted, which indicate that an accident happened and that the treatment was necessary for the care, recovery, or rehabilitation of the person. Once that is done, there's a question of fact, and the case could potentially go to trial. The court in chiropractors went at length to cite Bari, Michigan Head and Spine, as well as Detroit Medical Center versus Progressive, which ultimately held, and they concluded that a healthcare provider's ability to recover an injured party's medical expenses under the No Fault Act is dependent upon the insured's eligibility for such benefits. The court also noted in dicta that they view whether an injured party is eligible for benefits is a different question than whether an injured party may recover benefits. The court said a party may be eligible for benefits under 500.3105, even though his claim is barred by a one-year statute of limitations under 500.3145. The court ultimately ruled that State Farm was not able to obtain summary disposition where the injured party did not cooperate for benefits. The provider's claim stood, and they were able to offer reasonable proof of the fact amount of loss sustained by submitting medical records alone. Thus, medical providers now have an extended ability to sue insurers simply by providing medical records alone. The biggest question remains is what to do and what are the best practices going forward. As it relates to Covenant and Chiropractors Rehab Group, those two cases, we will await a motion for reconsideration by State Farm or potentially leave to appeal, which would have to be filed with the Supreme Court. Generally, reconsideration motions are not successful, and the leave to appeal takes time for potential resolution. There is also the potential that State Farm sues Stockhold, their insured, on the Covenant case on the indemnification hold harmless, and if that is the case, or Stockford actually pays the bill, does the case then stand as binding precedent? As of now, we are unaware of any legislation that could potentially fix these issues. However, there may be a need for potential legislative fixes to these cases. There is also another potential avenue in which to address is whether the res judicata, collateral estoppel by way of dismissal with prejudice, does that issue have what we call a claim preclusion? Currently, there is a case pending in the Michigan Court of Appeals, VHS v. Sentinel, which addresses this as an attempt to bar the provider's claim. This argument gets into the technical aspects of what a true dismissal with prejudice operates as, and does it bar claims since there is claim preclusion. However, as of this time, each insurer now must deal with Covenant and Chiropractors Rehabilitation Group going forward. What happens when a provider submits medical bills alone with or without records? The most obvious and easy way to potentially resolve all issues is to follow what has been recommended in Covenant Medical, and that is to file a motion to determine proper payees and apportionment pursuant to MCL 500.3112. You must let all claimants know. This becomes a difficult proposition as, in some cases, the insurer is well aware of numerous facilities, labs, medical providers that have submitted claims that have potentially even been paid. However, the plaintiff might only be claiming a few medical bills. In that case, in order to effectuate a full and complete resolution of the claim, it is recommended that all providers, when you have received any type of bill, be notified. The next question also is in relation to the attending care and household service providers. We would also recommend getting notice to them. Even though case law has indicated under Hatcher, previously stated in this seminar, that the right belongs to the injured party. However, Covenant contemplates whether there has been notice and whether you have received a claim. Based upon Covenant, a household service provider or an attendant care provider may be able to get around a release. Obviously, a plaintiff attorney will not be happy with notifying all parties, as this will delay a settlement. However, in order to receive a full and complete release from all claims and to have the final aspect of litigation completed, the best practice would be to file this motion. Additionally, we would also recommend notification to all potential claimants by certified mail and or personal service. This will provide the ability to show the court that all individuals have been notified. The mail also may be sent by first-class mail in addition to certified and or personal service. However, this is the best way to obtain and satisfy any requests from the court that all parties be notified. Remember, this is the thing to protect the insurance company from potential litigation in the future. This would be the best practice, and yes, it is more tedious, more time-consuming. However, in order to obtain a full and complete resolution where there would be no more potentials for additional litigation to arise out of that settlement or potential exposure to double payments, then the best practice would be to have the motion. There's also now consideration of what would be done with mediation and case evaluation that occurs on a first-party no-fault case. Our current recommendation is do not accept any awards. If the award is accepted and the other party accepts, then pursuant to MCR 2.403, a judgment will be entered. This may not give you the protection that a motion to determine proper payees and apportionment will have. The judgment can simply be entered prior to a motion being granted, and there is no condition that a settlement be done with the motion being filed. Simply put, if both parties accept case evaluation, a judgment will be entered. Your counsel would have to immediately file a motion with the court to obtain proper payees and apportionment prior to that judgment being entered. The court rule does say that a mutual acceptance will resolve all claims to that date. However, the court rule would be in conflict with the Michigan No Fault Act, and therefore the statute provides will prevail over the court rule. Thus, you could be exposed to another suit. In regards to any type of facilitations of PIP claims, all settlements would have to be contingent on obtaining court-ordered resolution pursuant to MCL 500.3112, or in the alternative, if there are a few medical providers, make the resolution contingent on the attorney representing that each and all interests of all parties can be compromised and he has authority to represent each and every one of those claims. Another potential alternative is to obtain releases from every medical provider, attending care, and household service provider. But in each regard to the release, there must be some consideration. So a nominal amount of at least $1 would have to be put into the release prior to the release having to have full legal authority and effect. As it relates to indemnification and hold harmless in releases, this is a recommended aspect to have. However, again, indemnification hold harmless from an insured is only good as long as the plaintiff is collectible, or as we say, it's only as good as the paper it's written on. You must also consider any pre-suit negotiations or resolutions with claimants and how you wish to proceed with handling those matters. You may file a petition to approve the settlement pursuant to MCL 500.3112. Simply put, this would entail filing a petition with a circuit court asking for court approval, as the statute specifically authorizes an insurer or a proper person or interested person may apply to the circuit court for an appropriate order. Thus, on all settlements, pre or during suit, have a motion filed. If you do not wish to incur the expenses of the motion, then potentially settle only certain expenses in a settlement and leave others open subject to a one-year back issue, such as certain medical providers that have not filed suit that are coming up on a one-year back potential bar. The parties may decide to leave those claims open and not settled and wait to see if suit is actually filed. If a insured indicates that they are representing or presenting medical bills, there is another option, that a motion to strike claims based upon 500.3112, where the plaintiff cannot prove that they represent the provider. This is a potential novel concept in application of 500.3112 and the result of covenant, indicating that if the plaintiff attorney or the plaintiff cannot indicate that they are adequately representing and protecting the interests of the medical providers, then they should not be able to proceed with presenting those claims, as those claims would not be barred. Another idea is to place all providers' names on any checks with the insured, or in the settlement, place all potential claimants, attended care providers, household service providers, and medical providers on one single check. This would create quite an issue. However, it is a potential option. As it relates to dealing with chiropractors rehab group, the issue regarding potentially having an insured who does not cooperate and facing a provider lawsuit, it is recommended that a petition pursuant to MCL 500.3153 seeking an order barring the claim of all involved is filed. If other information is requested and not provided, then a petition for discovery pursuant to MCL 500.3159 would be the next course of action, and if non-cooperation, then request the ability to strike the claims in that petition. Clearly, these are attempts to limit the exposure of the carriers involved. The results of Covenant and Chiropractors Rehab Group are simply that the insurers and anyone else involved in the handling of no-fault PIP claims must become more aggressive in filing petitions to strike claims and bar claims based upon the available remedies under the No Fault Act. Since this is a new and developing area, there are concerns to be had, such as if at a hearing providers appear and indicate they are unwilling to compromise their claim. What does a carrier do as if the settlement is attempted to be quote-unquote blown up by a medical provider? Then can the carrier still maintain their resolution with the insured? The answer will depend on how the potential resolution is agreed to between the parties. If a settlement is contingent on 500.3112 approval, the court will have to make the determination as to the apportionment. The amount appears to have been agreed by the parties, and the court, in all likelihood, under 500.3112 would not have the ability to set aside the amount settled just to apportion the settlement amount. This, in essence, could end up being a mini trial on the amount that providers would receive. Where do we go from here and what lies ahead? Obviously, the most single-handed aspect is additional flood of provider lawsuits. Unfortunately, this gives the providers many more options, and potentially for the last year, any claim that has been resolved, a provider could go back and file a suit seeking additional amounts since the case was not approved by 500.3112. Clearly, the art picture at the bottom attempts to make light of the situation, but it is fraught with areas to be exposed based upon this case. Most obviously, we are hoping for Supreme Court direction as to whether this is the aspect in which all PIP claims should be handled, or will this case be overturned, at which time we go back to handling claims as we have in the past. However, based upon these two cases, it is apparent that more aggressive filing of petitions to approve settlements and to bar claims under the No Fault Act, where the ability to obtain discovery pre-suit should be utilized. The No Fault Act provides remedies for insurers to bar potential parts of claims when an insured does not cooperate. In order to protect the carriers from this, the aspects of the No Fault Act should be implemented as soon as possible. We are staying updated on any appeals or motions for reconsiderations on both cases, and we will update you accordingly if there are any updates. You may also wish to consider potentially settling portions of a claim that you can, such as wage loss, where an insured has no other claimants that could potentially affect the wage loss portion of a claim. The household services and attending care, even though there is case law indicating that those rights belong to the insured, those may also need to have court approval. Thus, we may see piecemeal settlements of litigation in an attempt to get portions of the claim resolved. We do not know how the plaintiff's bar will react to this, and whether certain plaintiff attorneys will simply leave medical bills outstanding and not proceed with attempting to resolve them. As one slide said earlier, this is just another brick in the wall that is a continuing growing trend of provider lawsuits. In order to help you understand what a 500.3112 motion would entail, we have also provided some information. The first would be to notify all medical providers, attending care providers, household providers, err on the side of caution if you want to obtain a full and final release. If there's no suits filed and you want to settle a PIP claim, then a petition in circuit court would be the best course of action. A settlement can still be for less than the amounts claimed, as the insured plaintiff still remains liable for any amounts. The court's going to discharge any and all liabilities for benefits in requested relief to the insurance company. This would also then relieve the insurance carrier of any balance bill issues that would ultimately have to be put back on the plaintiff. This can create quite an issue going forward. There are questions that still remain, is whether a 500.3112 motion would result in providers filing objections, or do they merely attempt to file a new lawsuit? Can they intervene at that point? In reviewing 500-3112, it does not create any substantive rights. It's just a settlement mechanism. A settlement still is a settlement. The court would mainly just apportion the amount. Thus, the case of Clark versus Progressive, which occurred in February of this year, where the insurer knew of additional medical bills but did not tell the plaintiff of the amounts the settlement stood. The plaintiff attempted to argue that the insurer had to notify them of any outstanding amounts they knew of. There is no duty still of the insurer to notify the insured of outstanding medical expenses in a settlement, simply asking the court to apportion amounts in a 500.3112 motion. I thank you for attending the webinar, and if you have any questions regarding this or any other no-fault questions, feel free to contact me. My contact information is attached, and I look forward to helping you navigate this wonderful aspect and changes of the law that we have. If you have any other questions, anyone else is available here at Seacrest Wardle. We look forward to working with you on these files and helping you through. Thank you for taking the time to attend, and remember, one last thought. Have a great day. Take care.